Hello everybody, I am Sana Parvez, your legal expert from Hitbullseye, and in today's video we shall be discussing the Supreme Court judgments from December 16 to 31st of December of 2022. In our first judgment, we shall be discussing Gaurang Gupta versus the Government of NCT of Delhi. This is essentially a PIL which was filed by Gaurang Gupta. In this case, Gaurang Gupta had filed a petition or a public interest litigation. In this case, he stated that uh, what you usually find on the streets, the images of deities, etc., they should be held illegal by the Supreme Court. So essentially, he asked the Supreme Court to pass an order for the public not to paste any such images on the roadside, on any such public walls, etc., and giving a reason, he stated that it is in contravention of a right given under article 25 of the constitution, that is right, fundamental right to freedom of religion. In this case, he stated that what happens is that it is considered a deterrent for the people to in order to keep the place clean. So essentially, a lot of times, a lot of civic bodies, what they do is they paste the images of deities on the public walls, etc., in the hopes that people are not going to cause menace in that area. Essentially, they are not going to spit in that area, and they are not going to urinate, etc., in that area. However, it is, in his opinion, it was disrespectful to the gods or the deities themselves. So that is why he found this thing offensive. However, when he approached the Supreme Court stated that first of all, the Supreme Court had already dealt with a very similar case in 2014, and in that case also the Supreme Court had dismissed that case. So the Supreme Court stated, first of all, the Supreme Court chided Gaurang Gupta, and the Supreme Court dismissed the application, stating that it is not for the Supreme Court to take care of this and pass an order regarding this. So it is not the ambit of the Supreme Court. Rather, it is under the ambit of the other civic bodies. So he can approach and file a plea to the other civic bodies, but not the Supreme Court, and not waste the time of the Supreme Court. In this regard, the Supreme Court further stated that this case is a fit case to file exemplary costs in order to punish that person for wasting the time of the court. However, the court also took notice of the fact that the lawyer, the advocate, was a young person, and the Supreme Court can let go of that person. So the Supreme Court let go of the advocate without giving exemplary cost in this regard. In our next case, Hamdard National Foundation India and Another Limited versus Sadar Laboratories Private Limited. This is a case of trademark infringement. In this case, what happened was the Hamdard company, the Hamdard Foundation, had moved to the High Court, that is the High Court of Delhi. It had moved the High Court, stating that there was a yet another company which was called the Sadar Laboratories. The Sadar Laboratories had launched a brand called Dil Afza. So the Dil Afza was deceptively similar to Roo Afza, and the people were getting confused. The common customers were getting confused in this regard as to which product is real, which product is not real. So it was very deceptively um, named by the Sadar Laboratories in order to get the products confused, and therefore the Hamdard Foundation moved the High Court, and the High Court formulated two issues. The first issue was whether using the defendant's trademark for similar items would result in infringement of the plaintiff's products or generate public misunderstanding as to the source of the product, firstly. Secondly, whether the High Court of Delhi had the authority to issue directions under 124 of the Trademarks Act of 1999 in order to deter, or in order to file a cease and desist notice to this other laboratories. In this case, the High Court eventually found that this other laboratories, the name that they had given to the drink or the sharbat, which was this dil afza, was actually very deceptively similar to rue afza. Afza is the same name. Afza is common term between both the products, and rue and dil, when they are translated to English, they both mean one and the same thing, or almost one and the same thing, and therefore people were getting confused. So, in a case where the other product, that is rue afza, is a well-known product, then in that case it would be a fit case for infringement of trademark under Section 28 of the Trademarks Act of 1999. So let us have a look at the Section 28 of the Trademarks Act. In this case, in this section, Section 28 gives the right conferred by a registration. Once your trademark is registered under the the Trademarks Act, what are the rights that the person who is the registered owner of the trademarks gets? Firstly, subject to the other provisions of this Act, the registration of trademark shall, if it is valid, give the registered proprietor of the trademark the exclusive right to use the trademark in relation to the goods or services in respect of which the trademark is registered, and to obtain a relief in respect of infringement of the trademark in the manner that is provided under the Act. The next two clauses confer to, essentially, when two people have the same trademark in the same name, so both of the people are the owners of that trademark, and they have a right to file a suit against everybody else but not each other. So they are immune towards each other, but they can file a suit against everybody else. However, what is concerned, we are concerned in this case with only the first clause, that is, in this case the Hamdard Foundation had a valid trademark against the world to market its product Ruafza as Ruafza, and nobody else can take that right from them. It was held by the it was held by the High Court of Delhi that the right had indeed been infringed by this other laboratories, and a cease and desist order was issued with regards to the same. In our next case, State of Rajasthan versus Gurbachan Singh. In this case, the Supreme Court discussed the ambit of Section 34 of the Indian Penal Code. The Indian Penal Code, Section 34, talks about the common intention. It talks about where one person, where two or more persons rather, they do an act and one person does an act in furtherance of a common intention, then all the people who are involved in that act and all the people who have physically done that act, firstly, they should be present at that place of crime. Secondly, they should have done something overtly, not covertly, overtly they should have done something, and it will be held as if that they did the whole crime themselves, and it will be considered they will be punished for the same crime. In this case, essentially, if you talk about the brief facts of the case, what had happened was Gurbachan Singh and 3 to 4 other people had armed themselves with, one person armed himself with a gandasi, which is essentially a dagger of sorts, and other people as well armed themselves with sharp weapons and dangerous weapons, while Gurbachan Singh, who is the accused in this case, armed himself with one lathi, which is not as dangerous as the other weapons. They went to the spot, and they went to the scene of the crime, and they spotted one Teja Singh. They started hitting blows at Teja Singh, and because of this reason, Teja Singh eventually succumbed to the injuries and he died on the spot. Now, the plea that was taken by this particular accused, Gurbachan Singh, was that he was armed with a lathi while other people were armed with more dangerous weapons. So it was never in his intention to kill that person, and the intention which could be inferred was only with respect to maybe causing grievous hurt, but not anything more than that. However, in this particular case, the Supreme Court stated that the common intention of a person can also be formed at the spur of the moment. So he might have thought, at when he must have been leaving from the place where he equipped himself with the lathi. He might have been thinking that he's only going to hit, but at the same time, when he met all the other people who were a part of that group, and when he started hitting blows, and when he realized that Teja Singh might die in this whole series of event, he did not retreat back. He was a part of the whole thing, and he did an overt act with regards to it, and he also became a part of the common design. So there were two things. One, there was a common design, and second, there was a community of purpose and common design. And that is why Gurbachan Singh was also held liable for causing murder of Teja Singh. In our next case, Neeraj Datta versus State GNCTD. This case is a very important case as it is a constitutional bench case. The constitutional bench was a five-judge bench case, and the five-judge bench was headed by Justice Abdul Nazir. In this particular case, it was relating to Prevention of Corruption Act of 1988. However, there were two essential observations that were made. One was with regards to the hostile witnesses under Section 154 of Indian Evidence Act, and the next was with regards to the Prevention of Corruption Act. So let us have a look at both the observations that were made by this constitutional bench. Firstly, with regards to the Indian Evidence Act, the court stated that the testimony of hostile witness can be considered to convict accused if it is corroborated by other evidence. Now, in this regard, let us first discuss who is a hostile witness. A hostile witness is a person who goes against who goes against a party who has called that witness. So for example, if the prosecution has called the witness who's a prosecution witness, and he makes a statement which is not in the favor of the prosecution itself, or for example, the defense calls a particular witness, and that witness gives a statement which is not in favor of the defense itself. In that case, this person becomes a hostile witness. In that case, a right which is given to the parties who called him is that they can not only take his chief examination, because in the chief examination is the fact that he has gone against the party, they can also take his cross examination as well. And after that, in this particular case, the court further stated or reiterated how Section 154 is to be read. They stated that at the time, what is the evidentiary value of a hostile witness? It cannot be treated that everything that a hostile witness is saying is uncredible or not worth of being believed. There might be some parts which might be believed in his testimony, because he does become unworthy of credit. So shall we discard his whole testimony at once, or shall we take some part that are making sense firstly, and that can be corroborated by other facts and circumstances of the case? So the court in this case stated that if there are parts of his testimony which can be corroborated by other material facts or other evidence, then those parts can be taken and his testimony cannot be wholly discarded. But the statements which are absolutely unbelievable, and the statements on which he's been going back and forth on, that can be discarded. Secondly, the second statement or the second observation that the Supreme Court made was with regards to the Prevention of Corruption Act, Section 7 and Section 13 of the Act. Under Section 7, the Supreme Court clarified that when an offence is made under Section 7 of the Act, it has to be, there is no requirement for a demand of the bribe. In this case, there is no demand from the bribe taker. In this case, if the bribe giver himself offers and there's an acceptance from the other side, it would constitute an offense under Section 7. However, if there is a demand from the bribe taker side, in pursuance of that demand, the bribe giver offers demand, which is again accepted by the bribe taker, then it becomes an offense under Section 31D2 of the Prevention of Corruption Act. So this is how this is actually two offenses, and they'll be categorized as such under Section 7 and Section 13 of the Prevention of Corruption Act. The next case is Pramod Singh Kirar versus the state of Madhya Pradesh. In this particular case, the Supreme Court stated that sometimes we see what happens is when if a criminal case is going on against a person, and even if he's been acquitted, he might face problem in employment opportunities. So similarly, there was a person who had filed a case, that is Pramod Singh. He had filed a case because his appointment had been rejected. His appointment was rejected on the grounds that there were proceedings previously there in the past. He had proceedings against him under Section 498A of IPC, that is cruelty by husband. However, in that case, how it resulted was that Pramod Singh was properly acquitted in this case with all due honor, etc. However, the committee appointing him stated this as a reason that previously he has undergone or he has been tried of such offense, and so he shall not be given employment. The Supreme Court set aside this order and stated that if he were convicted, then those would have been the correct grounds for not appointing him. But when a person has been tried and has been properly acquitted, then you cannot take that as a reason for his non-appointment. So this is our last case for the day, Sudesh Chikara versus Ramti Devi. In this case, the Supreme Court dealt with the Senior Citizens Act, or which is also called the Senior Citizens Maintenance and Welfare of Parents and Senior Citizens Act of 2007. In this case, the Supreme Court explained the ambit of Section 23 of the Act. According to Section 23 of the Act, the parents or the senior citizens can transfer their property to other persons on the condition that they are going to be taken care of and their basic amenities are going to be provided for. In this particular case, there was a woman who was an old woman who had transferred her property to her son and daughter, and on the condition that she is going to be taken care of. However, what happened subsequently was that the son and the daughter started to avoid their obligations and started to not take care of her. The old woman approached the court and asked for the transfer deed to be declared void on these grounds. The Supreme Court stated that under Section 23, there are two conditions that are required to be fulfilled. One condition is that at the time of the transfer of the property, there should have been a condition precedent that if the kids or if the transferees don't take care of the person, don't take care of the transferer with respect to amenities and all the other things, all the other basic things, then this condition then the transfer can be declared void. First of all, this condition precedent should have been there, and second of all, subsequent to that transfer, there should have been a breach of this condition precedent. In this particular case, the Supreme Court found that both the conditions were fulfilled, this and this, both the conditions were fulfilled, and therefore the transfer was declared void. This is all from our end for this time. I hope you all liked the video, and I hope you all got to know a little bit more about the legal updates during the month of December. If you do like the video, then please don't forget to like, subscribe and share the video. And please, for staying updated, subscribe. Thank you.